The Moral and Legal Status of Animals, Part 3, Animals and the Law. In Part 2 we considered a range of positions regarding our ethical obligations towards animals, but what about our legal obligations? The traditional position of animals within the legal system is an anthropocentric one. According to this view, only humans have legal rights. Wild animals are a form of natural resource available for human exploitation, and domestic animals are a form of personal property. In other words, in legal terms, animals are the same as inanimate objects. Were you to cause harm to an animal belonging to another person, the appropriate form of legal action for the owner of the animal to bring would be an action in trespass to goods. Over the last 30 years, however, two streams of law have emerged that seek to improve the lives of animals: animal welfare law and animal rights law. Animal welfare law seeks to protect animals from unnecessary harm, and by doing so appears to grant animals a limited moral status. Animal welfare legislation regulates the use of animals in educational and research institutions, in zoos and in circuses, in food production, and in the wild as pets. As Stephen White explains, at common law, domesticated animals are classified as personal property. However, the existence of animal welfare legislation in all Australasian jurisdictions suggests that animals have greater moral significance than their formal legal classification as personal property might suggest. Contrary to an understanding of animals as mere objects, even those philosophers who are most skeptical about an expansive moral standing for animals accept that the imposition of gratuitous suffering on an animal is wrong. Consider the following extract from Section 18 of the Animal Care and Protection Act 2001, Queensland. 1. A person must not be cruel to an animal. Maximum penalty, 2,000 penalty units, or 3 years imprisonment. 2. Without limiting subsection 1, a person is taken to be cruel to an animal if the person does any of the following to an animal. A. Causes it pain that in the circumstances is unjustifiable, unnecessary, or unreasonable. B. Beats it so as to cause the animal pain. C. Abuses, terrifies, torments, or worries it. D. Overdrives, overrides, or overworks it. E. Uses on the animal an electrical device prescribed under a regulation. F. Confines or transports it without appropriate preparation, including, for example, appropriate food, rest, shelter, or water, or when it's unfit for the confinement or transport, or in a way that is inappropriate for the animal's welfare, or in an unsuitable container or vehicle. G. Kills it in a way that is inhumane, or causes it to die, not to die quickly, or causes it to die in unreasonable pain. And H. Unjustifiably, unnecessary, or unreasonably injures or wounds it, or overcrowds or overloads it. Occasionally, statutory provisions such as this are relied upon to impose substantial penalties upon those found guilty of mistreating animals. In 2013, for example, a Tasmanian dairy farmer was charged with nearly 200 charges of animal cruelty against more than 180 starving and neglected cows. According to the animal rights group Stop Tasmanian Animal Cruelty, cows and calves were dying of malnutrition every day on the farm over a period of a number of months. The eyes, udders, and genitals of numerous cows had been pecked by crows. Others that were calving were put in steep, boggy terrain despite orders by animal welfare officers not to do so, with some found dead after falling in steep, boggy areas. The farmer was found guilty and sentenced to 15 months imprisonment, fined $110,000, and prohibited from owning livestock for 10 years. The sentence was one of the heaviest imposed in Australia for animal cruelty offences against dairy cattle. More commonly, however, the penalties imposed are minimal. In 2013, two 17-year-old boys were charged with animal cruelty after directing their pig dogs to maul 5 sheep in a paddock and then stabbing the sheep with knives. They were caught after photos of them posing with the bloody carcasses of the sheep were posted to social media. No conviction was recorded, and the boys were fined $10 for trespassing. It appears that the animal welfare legislation is concerned to ensure that animals do not suffer unnecessarily. However, the legislation also contains a range of exemptions, including controlling feral or pest animals, fishing using certain live bait, slaughter under religious faith, and compliance with an adopted code of practice. This final exemption is particularly important. An activity or practice that causes an animal to suffer in any of the ways set out in the legislation is not a breach of the Act if it is done in compliance with a code of practice that has been approved by the regulatory authority. Codes of practice have been developed for the pig industry, the domestic poultry industry, and the cattle industry. Note that a review of the model codes of practice in 2005 recommended that they be converted into Australian animal welfare standards and guidelines. Standards and guidelines for cattle and sheep have already been developed, and those for poultry are now in development. The current codes of practice legalize practices that would otherwise be classified as animal cruelty: factory farming, the castration of farmed animals without pain relief, cutting or grinding the teeth of piglets, the dehorning of adult cattle, the hot branding of cattle, the de-beaking of chickens with a hot iron or wire, the transporting of cattle and sheep for extended periods, the mulesing of sheep, cutting the skin from their behind without pain relief, flank spaying of adult cattle, and the tail docking of adult cattle, lambs, and piglets without pain relief. The fact that these and similar practices are legally permissible has prompted the emergence in recent years of another form of animal law, animal rights law. Advocates of animal rights law seek to challenge animals' legal status as personal property and to secure fundamental rights for at least some animals. They argue that animals should not be treated by the law as mere things, and that unless animals are recognized as having legal rights, they will continue to be treated by society as no more than resources to satisfy human wants and needs. Efforts to grant rights to animals have in recent years taken the form of initiatives intended to grant animals legal personhood and allow them to join our legal and moral community. Once recognized as legal persons, animals will be accorded certain fundamental and legally enforceable rights, such as the right to bodily liberty, which is freedom from unjust imprisonment, and the right to bodily integrity, which is freedom from harmful interference and experimentation. According to Stephen Wise, arguments for legal personhood fall into two categories: arguments from liberty and arguments from equality. The argument from liberty is that any being with the capacity for autonomy is entitled to legal personhood. Wise insists that our legal system is, at its core, designed to protect the interests of autonomous and self-determining beings. He presents evidence from ethologists and neuroscientists proving that many non-human animals, including chimpanzees, dolphins, orcas, and elephants, possess the cognitive capacities for autonomy and self-determination. The argument from equality begins with the legal principle of equality. Equal interests demand equal treatment under the law. A being is entitled to legal personhood if they are the same as other beings who already have legal personhood. Since very young children and cognitively impaired humans have legal personhood, so should any non-human animals that have equal or superior cognitive abilities. There's been some progress towards granting legal personhood to animals in recent years, although it has been slow. In 2015, a judge in New York granted an order to show cause and a writ of habeas corpus on behalf of a non-human animal. In a case brought by Stephen Wise and the Non-Human Rights Project, the judge issued an order to show cause and a writ of habeas corpus on behalf of two chimpanzees, Hercules and Leo, who are being used for biomedical experimentation at Stony Brook University on Long Island in New York. Under the law of New York State, only a legal person could have an order to show cause and a writ of habeas corpus issued on their behalf. The court had therefore implicitly determined that Hercules and Leo were persons. Unfortunately, the judge later issued a ruling in which she rejected the petition for a writ of habeas corpus on behalf of Hercules and Leo. In 2018, the two chimps were finally freed from the research center and were sent to the Project Chimps Sanctuary in North Georgia. Other initiatives by the Non-Human Rights Project include efforts to liberate Tommy, a privately owned chimpanzee living in a cage in a shed on a used trailer lot in New York, Kiko, a privately owned chimpanzee living on private property in New York, and Beulah, Karen, and Minnie, 3 elephants being held in the Commerford Zoo in the United States and used for circuses and entertainment. The Non-Human Rights Project has recently expanded its work into other countries beyond the US, including Switzerland, Argentina, England, Spain, Portugal, and Australia. In the next part, we'll consider the moral status of non-animals, including efforts to extend legal personhood to non-animal entities.